What is up, everybody? Welcome back to the internet where your cesspool is my jacuzzi. How's it going? This is good timing because I was just clocking out of work as this came to my attention. So, um, yeah, I don't know if you guys had heard, but there was that motion this morning that Judge Mata put in, and it was on the motion to vacate the judgment, motion for new trial, motion to alter amend judgment, motion for leave to exceed page limits, and she responded with this one sentence. It says, "It is ordered the motion is denied." So I think that is obviously what set off this latest post, and we will go through that together. Hey guys, hey Grandma Linda, how you doing? Colorado Canadian, what's up? All right, so I'll share that to my screen just in case, just in case y'all didn't see it. There we go. So that was from this morning. Hang on, let me see if I can zoom in a little. Okay. And like it was literally just the one line, and y'all know he does not like when she doesn't explain her reasoning behind her rulings. So there's that. Bruce says her ruling is shorter than the title of his motion. Yeah, like significantly. Significantly. Okay. D. Chris Ventus, hey, what's up? All right. Let me pull this up real quick. Hey, class of 83. Hey, everyone. Sorry, I can't say hi to everyone individually. All right. So the tweet he posted with it says, "I didn't want to do this, but today's LOVCE development needs some explanation. Again, I will ignore my better judgment and leave comments open for now." I think he's talking about his Twitter, not the blog, unless has been turning off comments on his blog, but I don't think so. Says fair comments, questions, criticisms are fine. Hate will be blocked, and we'll turn comments off. Okay. So, and then somebody responded, of course, with the age-old question. I asked it in an earlier post, but will Laura be going public with a real ultrasound? If she does that, many people would be willing to change their minds. Oh man. I mean, that's not going to get an answer. At least not a truthful one. Okay. This is interesting. This here, the big old. Listen to me, big old, the big old free speech zone sign right there. Like, okay, but I feel like he's a little selective about that. Yeah. Um. Okay. LOVCE Into the Void is the title of this blog. Okay. Um. Hold on. I don't know if you guys can see that. Let me zoom in a little more. Is that too big? No, I think we're good. Great question, Dish. What was Dish's question? Erica Murphy, thank you for the 3. Thank you for the super sticker. I really appreciate that. Very cool. I appreciate all the support, guys. Okay. You're good, Alita. I just started. Teresa says, "How long until Medium spin the wheel? Whose private Discord comments will get the lore out of context treatment?" Well, somebody said that she was at some horse thing, so I'm feeling like she's probably not going to be writing anything right now. But I could be wrong. But I don't know. I don't see it. Maybe she's taking a few days off the internet, which would be a great thing for her, I think. Baby Spice Dish, thank you for the 2. JFC submods, love you. And I love them back. Thank you for the 2. I appreciate it. Oh God, Jim. Jim. God, I'm not reading that out loud. Okay. All right. You won't believe this. No, really, you won't. But I do not want to blog about Owens v. Echard anymore. Or at least not at this current phase. You're right, I don't believe that. I have better things to do, and the case isn't at a place where there's much important new stuff to discuss. That will come later, probably, but not now. Okay, well, when you keep throwing new stuff out there, then yeah, there's kind of new stuff to discuss, but I digress. That's fine. Um, on the other hand, with so much inaccurate information being spread every day by the JFC cult, we're still harping on the JFC cult thing here. I see. This puts me in a difficult position. Do I ignore the BS, as I've tried to do since last month, or do I respond and try to set things straight? Okay. I know the JFC cult hates me with a white hot passion, but you can't deny what recently happened with the notice of change of judge. At least some of the less extreme JFC fanatics stopped for a moment, looked at the facts, and realized, Jesus, Gingras has a valid point we can't refute. Um, hmm. Don't deny it, you did. So let's think about that. Yes, there was a point that he, was accurate on, which was that in her testimony, Dr. Deans at the trial did not testify that to Planned Parenthood being closed on Sundays. I'm not gonna try to deny that, because like, what purpose would that serve? I was just like, no, she didn't. You're wrong. You know what I mean? Like, no, I'll give credit where credit's due. That is accurate, and I believe the judge made a mistake and accidentally misattributed her source of that information. But I believe that it was somewhere else in those exhibits that we are not able to see. We, the public, cannot see those exhibits, and that's where I believe that information is included. That is just my speculation. So, Winks, thank you for the 10, for being so lovely. Thank you very much, and thank you for modding and for always hanging out. I appreciate that. You guys are awesome. All right. Okay. So even though it is really, really, really hard to change the minds of people who made up their minds months ago, and even though I have seriously enjoyed not talking about this case, there is still a glimmer of hope. There is still a small chance that some people might stop drinking Clayton's Kool-Aid. Sir, I don't know what Clayton's Kool-Aid is supposed to mean to you, but it sounds to me like your client drank Clayton's Kool-Aid. And I don't drink that brand of Kool-Aid. So, even just for a minute, and they may finally realize the truth that there are serious problems in the way this case has been handled, and those issues deserve public attention, concern, and perhaps corrective action. Nope, now we've gone too far. Okay, so I basically have two options. One, allow the JFC cult's one sided and often incorrect narrative to be the only public commentary, or two, when important issues arise, offer my own comments to explain my views about the legal rules, procedures, etc. I don't love either option, but I think the harm that comes from option one requires me to go with option two. Yes, sir, it does seem like you are going with number two here. With that said, here's the deal. Earlier today, Judge Mata issued a one-line order, and I think he's got a link to it here. Let me make sure it's the same thing that we just showed. Yeah. Issued a one-line order denying all my post-trial motions, motion to vacate the judgment, motion for new trial, etc. Is that a big win for Clayton? Obviously, JFC thinks so, but here's why they are so wrong. Okay. So we're going back to that top paragraph of what we're seeing right now, where he's talking about like the serious problems in the way the case has been handled. Like, no, dude, no. Like, if you want to harp on your one actual point, do that, man. And like, nobody can refute that. But that's it. You have that one little point, and actually the context in which you put that point makes it really useless. So, dude, like, this is not helping. Omar, what are you doing? You want a link? Let's see. Class of 83, thank you for the 2. Stop calling us a cult. Do we need to sue him? I mean, I don't have the time or desire to do that. So, here, I don't know if you're busy, Omer. You might be working, but I will send this to you anyways, just in case on your email. Okay. Okay. Yeah, I just sent it to you. It should be in your inbox. Thank you. Sorry, guys. Let me see if he's going to pop up in here in a second. I want to make sure I don't miss him. First, as everyone knows, on July 8th, I filed a notice of change of judge for cause. Yes, you were a giant raging douchebag in that notice of change of judge for cause. How could anyone forget? But, sorry, I was looking at my text. That notice was based on Rule 6.1 of the Rules of Family Law Procedure, which allows any party to ask for a new judge when grounds exist. In this case, we argued Judge Mata was biased and that she had acted improperly for reasons explained in the notice. Nothing about her daddy this time? Okay. I understand most people following this case are not lawyers, and that's fine. But we have at least one that can pop in here. So but at the same time, if you are not currently licensed to practice law in Arizona, and if you do not have substantial experience practicing civil litigation in Arizona's trial and appellate courts, you really need to be careful about rushing to judgment regarding what you think the law says. I would beg you to take your own advice, my dude. Ugh, yikes. Although I don't follow this... That's funny. Although I don't follow this case closely on social media, when I do see comments, mostly forwarded by Laura and others... Okay. Easily 90% of the JFC comments about the law are simply dead wrong. Well, we have that in common, my good man. First of all, I don't buy that. That is actually the least believable thing on this blog post for me, that he's not, following on social media, because he, like raged out at like Dave Neal and Megan Fox and all that. And like he can say, yeah, sure, it's just what Laura sent me, but like I don't believe that. I don't believe that for a second. Bruce, does he present any new information? What is his point? Well, it's a great question. Oh, hold on. Hey. What's up? Do you know that you're in here yet? I can hear something. Hey. You are. Oh my gosh. I'm echoing. Yeah. So what were you saying in the comments there about the judges when it's a one-line statement or whatever?
Oh, I was getting confused. I had your stream on in the background and it was echoing.
Oh yeah, dude.
Okay. Yeah. The point that you were just making, and I apologize. I'm not coming on camera. My desk is a mess. I've been working
good, man.
On a motion for a big live stream tomorrow morning. But to your point, well, to his point in this blog post, oh, you guys said I had a point. That one small point that he made.
Yeah, right.
Look, I read his motion in real time, and when I read his motion, it was literally live on stream, and I was reacting to it in real time, and I had this holy shit moment. Did Judge Mata really screw this up? But there was a couple layers to that. Number one, there was a question of whether or not she misremembered the evidence or misattributed testimony, or what that was all about, whether or not she was actually Googling, and if she was Googling, then what were the ramifications. The other layer to that was how tangential to that was the actual ruling, because 99% of her ruling had nothing to do with that one point that she made about the closing times with Planned Parenthood. That fateful Sunday, July.
What is that, like a smoothie bar for moms? Jesus.
There's an idea, man. You might want to clip this one.
Oh
planned.
yeah.
What did we say? Planet Parenthood.
Yeah.
The shadiest, shiftiest daycare center ever. I
Mm.
wouldn't trust it.
That's terrifying.
Yeah, so I feel like that's if that's what he's referring to, yeah, full marks for recognizing that. But when you got into the meat of the motion, it doesn't mean a whole lot to anybody else because a lot of his motion I felt like was probably AI generated anyway.
Yeah.
But the rest of it was just lacked any meat, any sustenance. He was quoting incorrect cases, cases in incorrect jurisdictions, and all of the other stuff. The bloviating that he always does, his adolescent usage of prose and trying to like mimic Mata's, oh, my daddy's over here, I'm gonna make him so proud and all that.
I'll never get over that. Like, I'll
Yeah.
never get over that.
And you know what? You know what's funny? I missed that initial point when I was going over his life because it was on the very last page,
Yeah.
and I was over the trying to read his characterizations of the facts because I knew they're ridiculous.
Yeah.
I was really just looking for the meat. And then I said at the time, hey, there might be something there. I don't know what that's about. I don't know how much it's going to affect. And then I asked those legal questions. And then the more I thought about the case, oh, this is not going to be anything. And so when you get this ruling back today, which of course this isn't the actual motion that I had read, this was something separate that he filed. It was a procedural thing. But when a judge issues a one-word dismissal, that is a statement that there's nothing to this. There's no explanation needed. Appeal me if you want to.
Yeah.
The record's all out there. Do what you want to do, sir. And so,
right.
No,
he seems to be like triggered by the one line thing because he got like mad in a filing somewhere he wrote. I think it was a filing, maybe it was a blog. I don't know. They all kind of sound the same to me at this point, but like he had written something about like she, denied my motions without any explanation. It was just one line. It's like, okay, well, she's allowed to do that, right?
no explanation needed, sir. It's like
yeah.
the only reason why judges they don't have to give you an explanation. In certain cases, they do. Like when you do something like really egregious, that's severely questionable. There are certain statutes that require, okay, so this person is a convicted child molester or something, and you want to give him unsupervised visitation of the child, you're going to have to explain yourself, judge, if that's what you're going to do. That's written into the law. But this kind of a case, no explanation needed. The reason why judges write those explanations is to allow appellate courts on appeal to kind of go through their reasoning process, point them in the right direction. In the case, it's going to be on appeal. And you'll see judges sometimes even on the record say, okay, I'm going to make a record, I'm going to deny your motion, and I'm going to tell you why. And then they'll go in some long explanation. Other times, motion dismissed, we're moving on. And then you see it a lot with pro pers. People that are representing themselves, they'll make the big point. It's like, okay, so are you making a motion to flip custody? Yes, and well, I'm going to deny that motion. So do you have anything else? Well, I'd actually like to talk about the other point. No, we're moving on. If you want to appeal me, then appeal me. That's literally sometimes how it plays out.
Yeah.
So when you find a one-word dismissal of a motion, it is a loud and resounding F you, appeal me if you want. I'm done with this. I've entertained it long enough. I get your points. And and there's a long laundry list of frivolous motions that led up to this one-word dismissal.
Let me skip ahead to this part because this is something I was interested in. It says, first, the order today is void. That means it literally doesn't exist because Mata had no authority to issue this order while the notice of change of judge remains unresolved. And no, the notice has not been denied as of yet. So what do you think about that?
I missed everything you just said because I was typing something.
It's okay. So he's saying this order that she put in today is void, and it does not exist because she has no authority to issue an order while the notice of change of judge is like unresolved. It hasn't been ruled on yet.
Yeah, she does, and she did. Appeal me.
Okay. So that was the first thing that stuck out to me when I saw this. I was just like, are you actually like, is this like a fairy tale land that you're living in? Because
this is my take on this is why I dislike lawyers so much. Not every attorney is like this. Not every attorney is like a shyster, sleight of hand type of person. But Gingras does this thing where he will arouse a cloud of smoke or kick up some dirt or dust and try to conjure up legal points that don't exist, such as what you just read. She can't do that. This isn't a valid order. Yeah, it is. then just file the appeal. We're done. I feel like in the course of this entire litigation, the judge, specifically Judge Mata, has gone through great lengths to explain her decision-making process and given out thoughtful responses to motions that were already decided upon, so that appellate courts could have a full record of how she was evaluating her record that was in front of her at the time she's making such decisions. And so we're far beyond that point, and he keeps on arguing these same points and issues, and which is why you're seeing the judges now. It's like, you know what, just it's dismissed, almost Darrell Brooks style, how he kept on arguing for subject matter jurisdiction. Your Honor, I don't see how you've proven subject matter jurisdiction in this case. Why don't we have a discussion about that? I've heard you, Mr. Brooks. We're moving on. You can appeal. This is kind of a similar kind of thing. It's not to that extreme. All I'm saying is that kind of stuff works against non-lawyers. So you know who that would work against or work on? It works on his client, Laura Owens, which is what I suspected he's been doing for a long time. Hey, I know that it looks really bad. I know that we keep getting our ass kicked in court. I know that every single motion we've ever filed has been denied. But look, here's what I know. And then he'll kick up his fairy dust, and try to conjure from some words from the dust to get his client to believe in what he's doing. And now he's just putting it and documenting it into a blog. One thing I know about Gingras is he's never been afraid to misstate the law.
Yeah, it seems that way for sure.
He's never, ever been afraid to take positions or perform actions that are counter to what every lawyer knows what's going to happen. My exhibit A with that would be Maricini. Opinion as a witness. If you show up, there's a restraining order. I'm calling the cops. Now, look, I argued, there's lots of other attorneys that argued and explained that that's not really a thing that you could do. He was subpoenaed. There's protections in place. It's written into the rules of court. I think the judge even issued some kind of a statement or explanation of why she wasn't going to do anything about it. And then he brings in the SWAT team. And so when you have a guy that's willing to go to that length, that level, where he's willing to use the county's resources to entertain this brazen ignorance towards the law that he's willing to display, then you can't really take him seriously at this point. I was shocked when I read that motion. Oh yeah, she really did do that thing, but then he ruined it with all the other stuff.
Yeah.
Like if I was grading, like if that was a paralegal or first year associate that brought that to me for my review, the first thing I would have pointed out was, hey, dipshit, why are you quoting Minnesota cases for an Arizona state case?
Yeah.
You're going to want to fix that immediately. Obviously, we're not filing that. But, he's, I don't want to say he's doing it on purpose, and he's not doing it on purpose. I just think that he doesn't care. He knows he's not going to get in trouble for it. He already knows it's getting denied, so it's not serious to him. Yeah. So it's the main reason why I've primarily just decided to stop covering this case altogether, unless there's a reason to cover it.
Right.
Like, for example, this one word judgment, somebody in the comments like, oh, we need your expert opinion. No, you don't. It's just dismissed because they're tired of his ass. That's it. That is my expert opinion.
Yeah, I hear you.
Oh, in other news.
So this part here, I guess it's kind of funny that we're reading this now after you said all that. It says, I get that JFC doesn't care about the truth. I also get that JFC is allowed to claim that I don't know the law. That's why we have courts to settle these disputes. But here's the deal. JFC wants to fight this battle on social media, not in court. And JFC thinks the order today is a win for Clayton. That's absolutely wrong as a matter of law. So,
I feel like he's talking specifically about me. Because
that kind of sounds like it, dude. I'm not gonna lie to you.
There was a point in time where I was giving him props for that motion for like maybe 15-20 minutes. And I've said repeatedly that this guy obviously doesn't know the law, or he's doing it on purpose. I feel like he's directing this towards me. And look, you don't need my validation. You really don't. If he knows the law better than I do, I'd suspect he'd be winning some of these motions. But I also know, as part of the appellate process, part of what he's doing is making a record so that he can attack it on appeal. And so there's some kind of method to what he's doing. It's not that he doesn't know the law. It's just that he doesn't care. Yeah. He's going to misquote it, and he's going to do what he wants. And it's not going to have any procedural effect in his ability to make an appeal. And what do you do when you have a losing case? What you basically do is you try to confuse the shit out of everybody. as best you can.
It's kind of working on me sometimes, you know, like, because I'm obviously not familiar with this, like the laws, the specific laws and stuff like that, and I'm just like, what's going on? Like, am I stupid? Are you stupid? Which one of us is stupid?
No, no, I've never questioned anything about this case,
Yeah.
in terms of the merits of the case.
Mhm.
And so I felt like when I started going in, hey, folks, I can't just dismiss this one offhandedly because there might be something there. And then I had to actually do some of my own research and figure out what was going on. And then comes to find out it's just a big nothing. There's nothing
Yeah.
there
Hmm.
ultimately. But you know, with him, I mean, he does this, and I feel like, I don't know, man. I don't know how closely he's following. It almost feels like everybody's kind of moving on from this case. I
Yeah.
feel like that's just been like Dave is doing different stuff, Megan's doing different stuff. You and I were just talking about the Trump thing the other
Mhm.
day. People were talking about your voice, and it's like you have like the perfect voice to be like an audio book for children. It
Yeah,
has like
I don't know. I've never read a book to children, but I'll let you know. Like, you'll be the first person to know if that ever happens.
it was like who does your voice sound like? You sound like one of those characters on Inside Out.
I haven't seen that yet.
I had it. Well, I've seen it with my children. I actually
Mhm.
took them to the actual movie theaters because it was, you know, that's like a very boomer experience nowadays. People don't really go to movies anymore.
I do. I go alone. Like, I go by myself. I get a tub of popcorn, a giant icy, and I'll sit there and like
Yeah,
watch Cocaine Bear by myself. Like, I don't care.
I totally used to do that. I was a big go to the movies by yourself guy
So
long
yeah.
time ago, pre COVID. But you know, my children are
Mhm.
not really,
Yeah.
especially the 4 and 5 year olds. So they got that experience. And I'll tell you what, never again. Why is that? Like, why am I taking them to the movie theaters, spending like $80 on like candy and popcorn and junk, and trying to tell them to be quiet and sit still in their chairs when I can just do that at the house
Yeah.
without bothering anybody? Same deal. Pay $15 to stream the whatever brand new movies at the theaters. I don't know, man.
Yeah. That's fair. That's fair for sure.
Oh. But yeah,
Okay.
I was gonna say where my characterization of your voice came from is that you sound a lot like that one lady from Inside Out. She's the part of the brain that is responsible for um like emotions or depression or something like that.
Oh, that
I don't
tracks.
know. But you just have this very calming voice.
Uh,
And that was what I pictured it as. I disagreed with that one commenter.
yeah, that was confusing. I was like, "Are you okay? Like, what are you talking about?" So yeah, some people are just weird, man. I don't know.
I'll tell you what, my wife has a squeaky voice. I think that
What
was the
does
word
that
you used.
mean?
Squeaky or screechy?
So they wrote squeechy,
Yeah.
but like screechy makes more sense because it's actually a word.
I mean, screechy, I pictured that being like pterodactyl-ish, you know, like a high-pitched seagull sound when they've discovered a fish in the ocean. I don't know.
Yeah,
Um, it's the sound that I imagine when I'm hearing my wife's voice in my head, asking me to do stuff.
gotcha.
After I've just sat down and relaxed after a long day, that's the voice that I'm picturing. That's my definition of squeechy.
That's fair. That's fair. Uh, okay. So this here, he's saying, he's talking about the Family Law Rule 6.1 about the notice of change of judge. He says, on filing of the affidavit for cause, the named judge should proceed no further in the action except to make such temporary orders as are necessary to prevent immediate and irreparable harm from occurring before the request is decided and the action transferred. However, if the named judge is the only judge in the county, that judge may also perform the functions of the presiding judge. And then he says, got that?
Okay, to
Yeah.
that point, there's actually that's actually a meritorious question
Hmm.
that he's asking. He's not asking, he's telling you that Judge Amata could not have made this ruling. It was the only question that I had for a split second was, why is Judge Amata ruling on this? I thought this was going to the presiding judge. But just understand that the presiding judge in Maricopa County understands what's going on, and the fact that Mata is still the one ruling on this lets you know how little they think of Gingras's emotions.
Hmm. Yeah. That's
So
awesome.
she can 100% do and be the person to make the ruling.
Hmm. Okay.
But I
So,
will tell you this, if Gingras was to succeed on appeal and the appellate court finding that Judge Mata abused her discretion, then it would have the effect of invalidating all of her subsequent orders after the fact, after the trial. So just the fact that the presiding judge in Maricopa County is allowing this to happen lets you know that they are gambling in favor of Gingras is going to lose.
Yeah. Well, I mean, that seems like a safe bet, but
I agree.
yeah. All right. He says this shouldn't be that hard to understand. If the judge assigned to your case is biased and unwilling to follow the law, you have a legal right to ask the presiding judge, Mata's boss, to look at the situation and determine if you are entitled to a new judge. While that request is pending, the case is placed on hold. The rule says while the notice is pending, the named judge, Mata, should proceed no further in the action. The only exception is to make temporary orders to prevent irreparable harm. Obviously, that exception doesn't apply here, so once again, Mata has ignored the rules and done something she had no right to do. So what happens next? What happens when a judge ignores the law and continues to make rulings in the case after a notice is filed?
Yeah. Well, a lot of assumptions made there. I mean, one of them is that Mata's doing this on purpose. The other is that, the presiding judge hasn't already reviewed and allowed it to happen.
Mhm.
I mean, you already saw the YSL case. The judge got removed over there.
Yeah.
And that's kind of the way that they work. They did it, and they didn't even admit that the guy did anything wrong. They just said, look, it's in the public interest to know that they can have faith in a judge, and whatever happened was a bad look. So I'm not saying you did anything wrong, but we're going to change judges.
Mhm.
Here it's like, yeah, we know what you wrote, but we have found no evidence of bias. And indeed, there wasn't any evidence of bias. The one point that he had that she may have mischaracterized testimony doesn't speak to bias.
Yeah.
At best, it speaks to the possibility that she obtained that information from some other source, and those other sources could have been within the record that she was entitled to look through. But it didn't speak to bias at all. Other than that one valid point that he had, there was nothing evidence-wise or argument-wise that led to any belief that Judge Mata was biased, unless you want to give credence to, her dad was in attendance, which he never explained fully why that would have made her particularly biased. He went on this diatribe about how judges are not allowed to consult with outside people, which is and I don't want to because I'm gonna butcher what he was trying to say, but if something about the appropriateness of consulting with other judges about outside facts or something like that, which would have been true if he could pin that down, but there was never even an argument suggesting that happened here. It was just basically raising the mere possibility that perhaps it may or could have happened in an alternate universe, because quantum theory and all of that, string theory, and anything is possible, which is not the same as demonstrating by clear and convincing evidence that bias was afoot. And so for those reasons, where was I going with this? How did I get off on this?
Let me think about that. How did we get here?
Oh, because he was trying to say, so there hasn't been not only has there not been a demonstration of bias, but it was barely argued that bias was a thing in the case anyway, other than him reciting the bias statutes, which is not the same thing.
Yeah. So before you came on, I don't know if you were watching at this point, I had read a tweet that somebody, Miss Medusa, had responded to his tweet. She says, I asked in an earlier post, but will Laura be going public with a real ultrasound? If she does that, many people will be willing to change their minds. Well, he just responded and says, if you ask that question, it's clear you haven't followed the case, because that question has been asked and answered about 12 quadrillion times already. And I don't think it has. So, okay. Yeah, he's going off on the Twitter now, but I'll look at that later. So yeah, he's just he's having a bad day, I guess.
Yeah, what was her question again? I missed you reading it. I just got your response.
She was asking if Laura would ever come forward with the real ultrasound, like the one she claims to have from Planned Parenthood, and said that people would probably be on her side if she did come forward with that. And he's just like, that's been asked 12 quadrillion times or something.
Well, to be fair, it has, because that was my one question. I literally asked Gingras that myself. I said, hey, so does she actually have any real evidence that nobody has seen yet?
Yeah.
Because that would be very helpful. And he gave me some bullshit answer, just kind of blew it off. I know lots of people have asked. He's probably right. It has been asked and answered. And I think the reason he's so frustrated is because obviously no. It's really what he wants to say. Obviously not. So stop asking me already.
I think for me, it's just like I still consider the question unanswered because I feel like all the answers have been non-answers. So I'm just kind of like, I don't really count that. But no, I can definitely see where it's been asked a million times.
Well, yeah, it's never been answered. And, not answering it is the same as an admission that it doesn't exist.
Yeah. Well, usually when he's not going to answer a question, he doesn't respond. But I guess now we're just being petty.
Well, you know what he'll do? He'll do this thing where he's like, you know what? I don't even have time to entertain this kind of question. I will not dignify it with a response. Or I don't read all the crap on the internet. I don't know what you're talking about. I've never seen any of those accusations whatsoever. That's the one that you try to play off with me. And it's like, okay, this guy's not actually serious. He's not, we're not really doing this, I guess.
Yeah. Okay. Here. Oh my God. What are you talking about, man? Hang on. Okay, so Finn Church, who has been on my stream before, was talking to him here because she tweets at him a lot, and then we got someone else, and he's saying, thinking of only of perjury, tell me one specific fact you believe Laura lied about. Don't need every fact, just the number one big one. And then he says down here, what do you think the elements of perjury are? Screw it. I will just give them to you straight from the jury instructions. And then he links to this thing that says the statement was made regarding a material issue, which is what he has underlined. So I guess he doesn't consider lying about the ultrasound a material issue.
Yeah. No, he does this thing where he gets very indignant and angry with his words. And then you're expecting the big point. It's like, and then he says something like that. You just don't know what perjury is. I'm going to say it one more time. Perjury has to deal with material issues. And it's like, but isn't the pregnancy thing like the material? No, it's not. It's okay. You're the lawyer. And then most people just back down at that point. But if, a guy like me listens to it, it's like, okay, so it's just 100% bullshit. Guy is 100% on full tilt. That's what it means to be tilted. Tilted Gingras. That's what it means when you're saying stuff like that.
Brianne Wilson, thank you for the 20. I appreciate that very much. Thank you, Lauren, for covering this blog. I bet they will never be happy unless they have hear a male judge. I mean, they're never going to be happy then. I don't think it's going to happen.
I don't know, man. I don't think he wants a male judge either. I'm not sure that would help. I don't know, because if you're a guy, you look at it from one perspective. If you're a female, you're looking at it from like the medical perspective and procedures and stuff. Guys would be, I feel like, focusing more on the lack of evidence of sexual assault allegations, and the emails that were received, which, to be fair, Judge Mata did. I just don't think it would have made a difference.
Yeah. He's given a couple examples here where AZ courts have voided like judgments that were placed in the context, but I'm going to skip that because it's kind of BS. All right. In Arizona, like most states, when a judge issues a void order, that order is literally treated as if it doesn't exist. Based on this, today's order denying our request for a new trial, etc., is void and thus has zero legal effect. But there's also a second problem. Today's order is not signed. It's what we call in AZ, or what we in AZ call an unsigned minute entry order. Why does that matter? It matters because in AZ, and again, virtually every court I practice in uses the same rule. Unsigned orders aren't final. That makes them very different from a signed order. Here's why. You can only appeal final orders from the court. Again, if you're not a lawyer, this may sound crazy, but while a case is pending, the judge may issue lots of different orders. Orders granting/denying discovery, orders extending deadlines, orders setting hearing dates, orders dismissing parties or claims, orders denying a request to dismiss parties or claims. The list is basically endless. Okay.
He's got a point there, but I don't know if that judgment is never going to be signed, or if that was expedited to the attorneys so that they could be aware that, hey, don't hold your breath on this. It's getting dismissed. So, yeah, he's correct that if it's not signed, it's a void order. He's correct that if Judge Mata is dismissed and she makes subsequent orders, it's going to be void. I agree. I just feel like they know that. And the fact that she's proceeding tells me that they've already denied his other motions. There hasn't been a finding of bias. She hasn't been removed, and she's not going to be removed. And they're not worried about subsequent orders.
Gotcha. Yeah. The expert over here. I was on the expert's stream last night, guys. He says, "Hey, Lauren, thanks for last night. Be sure and like it all." Guys, if you haven't checked out the expert, go over to his channel now. Our stream together is on his channel from last night.
Hey, is that the guy that goes on MG Law?
I think so. Yeah, he does. He does.
Oh,
Yeah. Actually, yeah, he definitely does. Okay, let's see. Where was I on this? I always get lost in his paragraphs.
oh, I know.
Okay. The law, however, is crystal clear. With only a tiny handful of exceptions, most orders issued in the middle of a case do not qualify as final. Under the rules, to be considered final, an order must terminate the entire case as to all claims, issues, and parties, and the order must be signed by the judge. If anything is left unresolved, or if the order isn't signed, then any order issued by the court is not considered final. Oh, and to help make things even more confusing, the rules do allow a judge to issue something called a partial final order or a partial final judgment. The post-trial ruling on June 17, 2024 was a partial final judgment. But to qualify as a partial final judgment/order, the decision is required to contain very specific language and findings. Any order that doesn't contain such language is deemed non-final and thus non-appealable. So what is the point of all this?
I
Well,
was just gonna say.
well, putting aside the fact that it's otherwise void, the order issued today is not signed, nor does it meet the requirements of a partial final judgment. Therefore, even if the order wasn't void, which it is, it would almost certainly not be appealable. That means the order is just kind of an odd, meaningless nullity. As a practical matter, it's exactly like this order never existed at all.
Yeah. Just as a practicing attorney, that's a load of nonsense.
Yeah.
Like that's the kind of stuff that you're losing the argument, and then you say all of that, and then the judge is like, "So what do you want me to do?"
Mm-hmm.
The judgment isn't signed. Well, here it is. I have a signed copy. It's signed now. Now what?
Yeah.
What about that there's a pending motion about her being potentially biased and all that kind of stuff. There may be a point to that, but the fact that she's making these orders leads me to believe that they must have either already ruled on that motion and just haven't published it, but they're going to, or they're operating under the idea that they're going to dismiss it in the future and it's not going to matter for the reasons that I cited. I am curious about that because that is, of all the stuff, out of all, I mean, you really got to just swim around. But out of all the things that he said, that's the most relevant things that he said so far. The fact that it is still technically, as far as I know, it's a pending motion. I actually thought that this ruling was going to be for the other thing, and it's for the new thing that he filed, which is a bit confusing.
Yeah. I think this is a question probably for you. Cat Lady Ballerina, thank you for the 5. I'm just wondering why, if he thinks all this is so egregious, why is he writing a blog about it instead of an appeal filing?
To pander to his client.
Yeah, that tracks.
Pretty simple.
Okay, yeah, we have a numbered list here now. Hang on. And this is almost over, surprisingly. I thought it was going to be a lot longer. Okay, got this all straight, folks. Let me just break it down as simply as I can. 1, the order today is void. What's that?
Well, breaking it down as simply as he can in the most complicated way possible.
Yeah, right? Oh, he's getting so triggered on Twitter right now. I'm just trying not to read it. Okay. The order today is void because it was issued by a judge who is subject to an unresolved notice of change for just for cause. Because the order is void, it has no legal effect. 2, the order is unsigned and therefore non-final. Why does that matter? It matters for 2 reasons. First, you can't appeal non-final orders, and second, Laura's time to appeal does not begin running until the court issues a final signed order. That comes straight from Rule 9 of the Arizona Rules of Civil Appellate Procedures, which states, you know what, I'm not going to read all this shit.
No, all right. I don't disagree with, on that point, though. He's right on that one.
Yeah. 3, because the unsigned order is non-final, Laura's time to appeal has not started running yet. You already said that, bro.
I know.
Literally already said all of this in the last number, but thank you for repeating yourself. 4, like virtually everything else in the law, there is a narrow exception that might permit, but not require, Laura to appeal the unsigned order immediately, even though today's order is non-appealable on its face. This post is long enough already. Yeah, dude. But if you really want to become an expert on obscure issues of appellate jurisdiction, read this. And then he's got it's a link to Barassi v. Medicine.
Just read the freaking rule, dude. Like he's quoting it. Is it the right state? It's the right state. Okay.
Yeah,
So
that's
there
too.
are two sentences in that case that explain what he's saying. All he had to do was copy and paste.
Yeah. Okay, yeah, I'm not going to read that part. I don't think this exception applies here because there are too many other unresolved issues hanging out there, such as the notice of change of judge plus the amount of fees. Number 5, all else aside, the issue of whether we will get a new judge remains unresolved as of today. The presiding judge may still grant our notice, in which case the matter will be assigned to a new judge, or she may deny the notice, in which case we will immediately appeal. 6, if Judge Fisk removes Mata from the case, this creates a real procedural mess because it means the new judge technically won't be able to consider the arguments raised in the post-trial motions to vacate, etc., since those motions have already been denied. I assume that is exactly why Mata issued the decision today, purely to try and block Laura from having a new judge correct the damage caused by the June 17th ruling.
It was strategic, a strategic denial. Come on.
But that plan is doomed to fail. And then he's talking about another family law rule here. Requires that void orders be set aside. We're talking about the same thing we already said. Okay.
Yeah.
So let's say in the next 30 days, Judge Fisk comes back and removes Mata from the case. We will then immediately bring a motion asking the new judge to vacate today's order denying Laura's post-trial motions, and that will open the door for the new judge to rule on those issues. Again, just like today's order never existed.
Well, here's the deal. It doesn't matter any of that stuff because his motion was for a new judge for a new trial. I forgot what else he was asking for, but that's essentially what it was. He wants a new trial. That's all it is. So whatever orders were made, it's probably true that if they're deemed to be void, it's as if they never existed. That means that he's not barred from refiling those motions as a brand new thing with a new judge. As if nothing ever happened. He wouldn't even have to appeal it. He just gets to file it as if it's brand new to the new judge. So it's actually just a moot point that he's making. And who cares? And it gets me back to my new point, or my only point, what does he ultimately want to do? Is he trying to convince whatever that I guess the point is his client shouldn't be subject to pay Echard's attorney fees. That's what he's trying to do ultimately, right?
Oh no! Gingras just made a comment about Omar on X. Let's find it. Anyways, keep going. Keep going.
I forgot what I was gonna say. Oh, I guess his point B is he trying to convince the public that Laura's narrative was true? Which I guess would be what Laura would be interested in, correct? Aside from the fees, I'm assuming, correct?
Sorry, I got totally distracted, man. What did you ask?
Oh, I got distracted myself. I'm just trying to figure out what is the point of all this. Okay, so he's trying to avoid Laura paying her fees. Number 2 is he trying to convince everybody that Laura was being truthful this whole time?
Yeah. Well, the truthful thing, I don't understand this harping on it's not perjury. Thing that he's doing on Twitter right now because he's getting so mad and he's kind of talking down to people, and then now he's like, no, I'm not implying you're dumb, but clearly you are, man. Clearly you are.
Oh,
I cannot find what they are talking about here.
I think I'm gonna have to jump on the X. Figure out what he said.
Yeah. Well, tell him to at you next time.
I know. I made it into a Gingras Twitter.
Yeah.
No, I can't find it. I just did a Control F on my name and found nothing. Maybe he already did.
Linda. Okay, she told me where to find it. Hang on. Oh my gosh. Nope, didn't see that.
Man, Gingras' Twitter is a mess.
Yo, dude, yeah, he's going off today. Yeah, I don't see it. I don't see it.
Anything. But you know what? Whatever he said about me is cool. I've said enough about him. It's not going to hurt my feelings one way or the other.
Yeah, I'm sure. Sometimes I like when he puts his foot in his mouth and then, gets told off. But hear me out. Thank you for the 5. Gingras knows cases are never won at trial. Victory is accomplished through endless motions and appeals being denied eventually. Okay.
Well, I guess there's that.
Yeah. Oh my gosh. This guy's crazy. Wait, did we not finish the last one? 7. Ultimately, even if Judge Fisk denies our request to disqualify Mata, that basically has zero impact on the case. We would simply appeal that issue along with everything else, and I'm confident the Court of Appeals will not look kindly on what has happened here. Thus, the Court of Appeals could still send this back for a new trial, and that would involve an automatic change of judge as a matter of right under a different rule. All this procedural nonsense aside, there will be a day when all these issues are resolved. One way or another, Laura is entitled to her day in court in front of a judge who is fair, unbiased, who cares about the rules, and who actually follows those rules. That day hasn't come yet, but it will.
So to put it as simply as possible, if he wins, then Laura's going to get a new trial. That's it. That's all he's saying. All of these motions are getting denied. All of these are appealable issues. Every single motion that gets denied, I'm going to appeal it. And, eventually we'll have our second day in court and prevail on the merits. What are we doing? At some point, there's one point where he made a statement after trial and was like, at some point, these two crazy kids got to move on with their lives, which is something that I always say to my family law clients. It's like, look, at some point, you guys are going to have to be co-parents. You guys are going to have to raise this child together. You guys are going to have to find a way to make this work or whatever. Now you guys are officially divorced. You can move on with your lives. And I very famously smoked a cigar with my youngest client. He was like 24 years old, getting a divorce. And got heartbroken. He's like, dude, you have no idea how lucky you are. You're 24, you're single, you got your own business, you got this whole thing. We lit up a cigar and we celebrated. And I was like, now you go forth and you go be single and you're going to enjoy every minute of it. As soon as that judgment was signed, it's like, he said, oh, this big weight was lifted off my shoulders. And it was this big celebratory thing. And at one point, Gingras had made mention, and we just did this whole trial and all of this stuff and all of this buildup, and now it's done. And so now what? Now maybe it's perhaps time for everybody to just go back into their corners and move on with their lives and, whatever. He's starting to talk like that. But then he gets so easily triggered.
Yeah, I can see that for sure. Somebody says he used the term tree phallus on Twitter. We're missing so much right now, and I just can't read it right now. I just can't. Because I'll sit here just like dumbfounded for like an hour and nobody wants to watch that. But like that's so crazy, man. I don't even know what's going on. I just know like some of the words that are being used and I'm already just like, oh my god, why are you doing this to yourself?
Oh, Mr. Gingras.
Yeah, right.
I feel bad for him, man, because I feel like maybe psychologically this guy's just like so lost in this case he can't get himself out of it and keeps on filing these frivolous motions and nobody really cares that much anymore.
Yeah.
And what's more is nobody has given him any credibility because of the nonsense that he said. And so forgive the general public if when he drops a motion like this, they dunk on him a little bit when his motions get denied, because very rarely has he said anything of merit in this case.
Yeah. Also the look at me daddy type stuff is just like, how do you not clown on that a little?
Come on, man. You can't say stuff like that and not expect to get clowned on a little bit.
Nathan says refresh. He just added more. Oh, oh God. Here we go. Okay. Okay. P.S. I forgot to mention one important issue that JFC has been consistently wrong about. No, Laura does not have to post a bond to appeal. That is a common misconception, and it's 10,000%, my bad, flat wrong. Has nothing to do with the issue of monetary versus non-monetary relief. A bond is only required to stop post-judgment collection efforts, but that shouldn't be an issue here. If you see anyone claiming that Laura can't appeal unless she posts a bond, please know this. That person has no clue what they are talking about. And no, Laura cannot, as a matter of law, be declared vexatious because Arizona law only allows pro se litigants to get that tag. People who are represented by counsel, like Laura, are excluded from the vexatious litigant statute. And then he's got a screenshot here from Reddit. Like he says that, like he doesn't read social media that much and stuff like this. And I'm like, yeah, you do. Don't even tell me that. It says, great insight from Reddit. It's a tweet. It says great insight from Reddit. And then he's written on it or not with a sad face. And and the comment says, I think this is his only plan. As I understand, to appeal Mata's ruling, JD would have to post bond for the amount awarded to Clayton. She apparently does not have the funds for that. So Gingras' tactic is to file these motions for a new trial, which is really an argument to be made on appeal. So I expect them to go nowhere. When they get denied, he can then appeal those decisions because no bond is required to be paid by JD for a non-monetary decision. When does this frivolous motions practice end? In my opinion, only these options. 1. JD is arrested and charged criminally. 2. Gingras is sanctioned himself by the court. Or 3. JD is declared a vexatious litigant. High bar, but she's well on her way. So I guess he's like pointing out that one tweet with a Reddit comment and saying like everyone's stupid, basically, but he's not.
Well, to be fair, I've never made the bond comment ever. Like I didn't know. Do you got to post a bond? And if you found an appeal in Arizona, I have no idea. I've never filed one. But I also know that it's not really a bar. Usually, when you have to post a bond like that, you'll get a bondsman. The same way you would in a criminal case, and just put up some collateral and go about it that way, and use that to go forward on appeal. I haven't actually even heard anybody say that she was required to post a bond. I've heard a lot of questions as to that. I didn't know what the answer to that was. I forgot the other thing that you said that he was harping on that people were getting wrong.
Yeah, I forgot too. There's so much shit, but
the vexatious litigation thing.
Yeah,
I don't know if it's true that that's limited to pro se clients. That doesn't make any sense. Because pro se people, by their nature, most of the time can't afford attorneys or to proceed. Well, I mean, I guess they could file a lot of frivolous things, but all I'm saying is I don't know that it's true that it's limited to pro se.
Yeah,
maybe it is in Arizona. I don't know.
Well, I guess we'll find out. But hang on, I got a couple things here. Let me see. Zach, thank you for the 5. Walmart, Ralphie May, what tree fallacy is going on here? What's your daily insult for me? Well, Zach, thank you. It's nice to see you, and I'm glad you called me Walmart, Ralphie May. Otherwise, I wouldn't be able to tell you apart from any other white man on a dating app because of your giant fish picture. Let's see. And he also says, thank you for the other 5, Zach. Also, can you tell me where Bruce is from? I suspect Cambodia. I think Bruce is actually from Canada, so you got that wrong. But hang on, let me see here. Somebody put this out. Brittany says, and I haven't read this tweet, but I'm assuming she's not lying. Gingras said Woodnick sounds like tree phallus on Twitter. That's the tree phallus. Okay. Tree phallus. Trees don't have a phallus, do they?
They're phallus like.
Okay. I get it now. Yeah.
Like a cactus, but that's
I was worried. I was like, did I miss something? Like, am I that uneducated that I didn't know that trees had a phallus? Like,
I mean, I guess you could carve a tree to have a phallus if you were really wanting to.
I'll keep that in mind.
Making art a statement of art or literature. I don't know, man. Literature.
Have you ever carved a tree, like carved anything into a tree?
When I was 7, I might have drawn like Ninja Turtles or something, or
Dude, that's hard to do. I feel like when you're carving a tree.
Well, you would take a stick and just like start chipping away, or I was probably playing with like little miniature hatchets because it was the 80s, and nobody was checking on whether or not I was actually safe.
Yeah, gotcha. When I was in grad school, I used to go hiking a lot. I lived in Tallahassee, and I was afraid of, because they had all these signs for like gators and bears and stuff, and I was just like, bears? There are bears here? Apparently, yes. And so I got really freaked out, but I didn't want to stop hiking, and like nobody was ever on that trail. Pretty much, it was like very quiet. And so I started bringing, like, I had these knives, and I had a rainbow machete, and I was like carrying it around. I was like, well, I don't know what I thought I was going to do with it, as if I was actually going to fight the fucking bear. But I did
that fight with the machete.
Yeah, right. And so I did at one point. I got up to the top of the trail before it wrapped back around, and I like carved with the little knife. I carved my initials into the tree and a smiley face, and I'm like, you're totally not supposed to do that, but I didn't care. So. But next time I will do a phallus. It's fine.
Violated a tree with your name.
yeah, I guess so. At least it wasn't a bear.
I mean, have you ever actually saw a bear like while you were hiking?
Not while I was hiking. I've seen a bear like crossing the road when I was on a not a bus, a trolley, like back up to a place I was staying in the mountains. But that's the closest I've ever come to a bear. So
I saw a bear. It was maybe 25 feet away. It was like down by the river somewhere, and it just was so uninterested in my hiking party that we were having. And it felt like oddly peaceful and safe. But now to think back about it, like what if that bear was hungry, had designs on protecting one of his cubs or something, that could have ended really badly.
Mm.
And we had no form of protection. It would have been like sticks and rocks and
Oh yeah, no.
I would have went.
This is making me want to watch Cocaine Bear again. Have you seen that movie?
Cocaine Bear? No, I was thinking. You know which one I was thinking of? That
Which
one documentary about that guy that was friends with bears, and that he disappeared into the mountains to go be one with the bears, and then at the very end of the documentary, the bears ate him and his girlfriend.
Wait, Timothy Treadwell?
Yes, I think so. The Grizzly Diaries or something.
Yeah, our English teacher when I was in high school had us watch that, and I can't for the life of me remember why. And I remember like he showed the whole thing, and I was like, when you hear like the stuff going on at the end when they're like getting eaten alive or whatever, I'm just like, oh my god, dude.
Yeah.
Yeah, that's crazy.
Joe Rogan always says that was like an unintentional comedy. He's like, come on, man. Why did you guys film it that way? And like the way that it was and like his personality and the way everything was shot, it just felt like a comedy that you were supposed to watch while you were on an edible or something.
Jesus. Somebody said something for you. Hang on. TN Trish. Not to be off topic, but Tilted Lawyer, your cross-examination of Nicole, is it Nicole Kessinger? How do you pronounce that? Was the funniest thing ever.
Yeah. If she likes that one, she has to catch the one I did with Megan Fox where Megan was playing Laura Owens.
Yeah, I saw that one.
I don't remember where that is in my live streams, but it's in there somewhere. Yeah, the one I did with Kessinger was played by my assistant Melissa, and I was going in pretty hard on her. She thought I almost kind of made her cry. I felt kind of bad about it, but it got really real for a minute, and we had to dial it back. Say, hey, this is just a mock trial.
Gotcha. Yeah, I need to watch that one. I obviously didn't know you until pretty recently, right? It's been within a couple months.
Yeah, this
and then so there's some older stuff. I go back and I'll watch it sometimes when I just have some free time. I'll put it on the background or something. So there's a lot of stuff I haven't seen yet, but and I haven't seen that one yet, but I'll probably get to it.
Yeah, I got somebody wants to play. I forgot who. Somebody wants to. People like the mock trial stuff, man. I've had like people volunteer to be specific people, and it's like, okay, I'll just prep a mock trial for. It's going to turn into a thing. I don't know when it's going to turn into a thing, but it's going to turn into something.
That's cool. Yeah, people seem to like it.
Yeah.
Hey, Rosalind, what's up? Pirate Master says he's now saying Laura can sue the court.
Yeah, you can sue anybody. Go for it. What
okay.
is
her Oh man, this guy's nutty. He's gonna stop tweeting. He won't.
Is he done on his rant?
Oh no, he's not done.
Oh.
Yeah, absolutely not. And I would honestly pull it up, but I don't want to unblock him, and I'm not logged into a burner account or anything on my computer right now. So.
Oh, you're fine. I'm like, I'm looking through his post. I don't know how to sort by most recent posts, and so I'm just looking at an amalgamation of all of his historic posts.
Yeah, I got you. What do I want to say this? Oh, here we go. I can do this. Cool. There we go.
Well,
I just want to find Tree Phallus, and then I can take a break for the day.
Tree Phallus?
Yeah.
I'm nervous to Google that.
I don't think you should Google that. Are you on like a work computer right now? I wouldn't.
Nope, it's done.
Okay.
Luckily, it's for the company that I own, so
yeah,
pretty safe. Yeah, I Googled it, and there's nothing really bad.
Mm-hmm.
What is this? This is a tree phallus. Phallus tree in the fertility fresco at Mass Maritima, circa 1265.
Well, you and I are probably looking at different things then. Let me show you what I'm looking at. Hang on.
All right. Let me find what I was looking at. Oh, it was this thing.
Phallic protrusion on tree.
See, that's what I had more closely in my head about what a tree phallus would be.
Yeah. Yeah.
That's more a proper phallus. If you look at mine, it's more just like hieroglyphs, whatever that is. Oh no, that's yours.
Yeah, well, I got a bunch of that on the top, and then there's like some weird stuff in here. Man, why have we derailed into this? I don't know, but I'm going to go ahead and and look at some more. What is this?
That
What?
that looks like somebody carved that.
It looks like a Gumby if he lost his color.
It looks like a demonic frog with his head severed
Yeah.
that is impregnating a tree.
Wait, why does that have to be the guy? What if it's the lady?
Is that a move for girls? I don't know. Maybe it is.
I don't know. I don't know. I don't do stuff like that with trees. But you know,
That's a
if I ever
historic
find out-
pose for a man. So I'm not sure if
This is just. This looks like a handlebar.
yeah, that's all right. What world are we in right now?
I'm not sure, but I might like it a little bit. Just kidding.
All right, Lauren. I gotta go do lawyer shit, man.
All right, cool.
Write a motion.
Thanks for coming in.
We'll do it
Yeah.
again pretty soon.
Yeah, appreciate you. Thank you.
You got it, man. You take care.
You too.
Bye-bye.
Bye. All right, guys. Let's look at some of this. Not more tree phallus, but but okay. Okay, I get so tired of this here. Honestly, I want to see if Laura put it. Well, I want to see Laura put an end to all this stuff, and she sincerely wants that as well. Clayton/Woodnick are the only ones who want to keep pushing this because why? Fame. Ask them. Laura would gladly end this tomorrow. Sure, she would. Yeah, they've been going back and forth for a bit here. Missy Ann, I love you and Omar together. Yeah, he's very cool. I'm glad that we met. Zach is relaying the insult of the day. Okay, let's see. Why would I block Rosalind? I'm not gonna block Rosalind. Indigo, did you pop in at the tree phallus part of this stream? Because if you did, I'm not sorry. Okay, guys. I want to look through these, but I just got off of work an hour ago, right before I started this stream, and I feel like I need to take a little break. So why don't we'll take off for a little bit, and then I'll come back in like an hour, and then we'll read the tweets. How about that? Does that sound okay? Baby spice dish. Y'all need to send Lauren some more super chats. I'm never gonna say no to that, but I just appreciate everything that everyone that's been supportive and sent those. I really do appreciate it. Missy Ann, I don't know about that. Okay, so let me go like eat something and then we'll get organized and then I'll come back here at let's say 7 p.m. Eastern, which is in 52 minutes from now, and we'll go through some of this stuff. Honestly, it'll give more time for more stuff to pop up anyways. So I'll talk to you guys soon, okay? Julia Ann, why are you sad? No sad face. I'll be right back. All right, guys. I will see you shortly.